Welcome back to This Week in Immigration. I'm Jordan LaPier. On the program this week, the U.S. begins sending asylum seekers to Guatemala, a look at how Remain in Mexico is working, why some migrants will have to submit DNA samples, and the immigration angle on last week's big Harry and Meghan news. All that just ahead. Before we get started, please remember you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you like to get your podcasts. And if you leave a review, it's going to help more people find our show. You can also stream This Week in Immigration on our website at bipartisanpolicy.org/podcasts. And as always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. And here with me today are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. She's on Twitter at BPC_T Brown. Theresa, Happy New Year.
Happy New Year, Jordan.
And Cris Ramón, Senior Immigration Policy Analyst on Twitter at CRamonBPC. Cris, Happy New Year to you.
Happy New Year as well.
All right, let's dive right in. At the end of December, the Trump administration said it would begin sending Mexican asylum seekers to Guatemala. That's possible because of the Asylum Cooperation Agreement between the U.S. and Guatemala signed last summer. That agreement initially focused on the process for Central American asylum seekers, but this new step signals an expansion of the effort. Theresa, can you explain what exactly is happening here and why some are viewing this as so controversial?
Sure. So it helps to understand the context that in the last few months of 2019, we saw a significant decline in the number of Central American families arriving to the U.S.-Mexican border. But at the same time, there was a slight increase in the number of Mexicans coming to the border and asking for asylum. And the policies that the Trump administration had put in place to deal with Central American asylum seekers, including the migrant protection protocols, couldn't necessarily be immediately applied to Mexicans. Almost all of those policies, including the asylum ban regulations, applied to third country nationals who had crossed through Mexico or other countries to get to the United States. So obviously that doesn't apply to Mexicans. So the administration, it became known at the end of 2019 that they were intending to use the asylum cooperation agreements they had signed with Guatemala to remove Mexican citizens who came to the border, tried to get asylum, and were denied under whatever process they're given, instead of sending them back to Mexico, to send them back to Guatemala. There are a lot of questions about that. Presumably, if they are denied asylum, they could be returned to Mexico. There's no reason, if they don't qualify for asylum or withholding, if they basically haven't proven their claim that they would be persecuted or subject to torture in Mexico, there's no legal barrier to the United States returning them to Mexico. The only reason I can think that they would be returning them to Guatemala is, frankly, to try to deter them or other Mexican migrants from coming to the border. It may be that they are also thinking, and you can surmise whatever you want on this, that in an overabundance of caution, since they have claimed that they would be subject to danger in Mexico, by sending them to Guatemala, somehow they are avoiding accusations that they're sending somebody back to danger. Again, many advocates would tell you that Guatemala is not necessarily any safer than Mexico for Mexican citizens, or Guatemalans for that matter. So this is just another avenue in the administration's attempts to reduce the number of people coming to the border and seeking asylum.
Cris, how does this decision highlight the differences you've discussed previously between these bilateral asylum cooperation agreements and other asylum management agreements?
I think the key difference, I've noted in previous podcasts that one of the key differences between the ACAs, as they're called, and other types of asylum management agreements like the Dublin III regulations in the European Union or the U.S.-Canada Safe Third Agreement, is that the receiving state isn't compelled to process the individual for asylum. It really leaves immigrants to their own devices as to whether or not they're going to seek asylum in the country. But this latest twist, I think, is pretty interesting because if it were to be really fully implemented, it doesn't matter whether an individual traveled through another country for this for the ACA to be applied. Ostensibly the idea behind the ACAs is that an individual would have traveled through Guatemala on the way to the United States and probably went through Mexico, and then be returned to Guatemala. That's how sort of these first entry asylum management agreements work. But the fact that there is the potential that Mexican nationals might be sent back to Guatemala and they're right next, and the country is literally right next to the United States, means that we're kind of dealing with something that's very, very different in terms of the mechanics of how it works. And I think that's really the key difference is not only is it non-compulsory, but it also just seems to be operating into a very different realm of how it works in comparison to first entry agreements. So I think that's the key differences.
Do Guatemala and Mexico have any ability to pressure the United States to change course on this?
In terms of Guatemala, what we've already been seeing is at least outgoing Guatemalan President Morales basically criticizing the decision and basically looking at it and saying, I don't think we can do this. And I don't want to follow through. So the Guatemalan lever that country has is essentially saying, we may not implement the agreement as you want us to. So that's the lever that they have. And the Mexican lever, the Mexican government has been obviously not terribly happy with the news, but the ambassador to the United States from Mexico, she kind of did say essentially, yeah, people will be deported back to Guatemala, but maybe they'll be returning back to Mexico. That's paraphrasing what she said. And I think that's sort of, they're trying to sort of play their cards a little bit carefully because they're working very closely with the United States on migration enforcement. So I think they're trying to walk a very fine line and trying to sort of think about how they can, approach this issue from a diplomatic perspective in order to pressure the United States. But I think the Guatemalan statement kind of indicates that Guatemala may not be entirely happy with this.
Yeah, I mean, the Guatemalan president, essentially, he's going to be leaving within a matter of a couple of weeks, has said, well, it's up to the next president of Guatemala to decide if they want to allow this to happen. So we're not implementing it. That actually caused Department of Homeland Security to put plans to start the deportation of Mexicans on hold. They had identified some Mexicans to go back to Guatemala, and they put that all on hold. The Mexican position, I think, as Cris said, is a little bit more nuanced. The Mexicans have said that they oppose this, that it is not necessarily in favor of their citizens being sent back to Guatemala, but how strongly they're stating their displeasure, at least publicly, is mitigated by the idea that I think they are trying to figure out how to keep working with the United States and fend off some of the threats, frankly, that the administration made on them earlier to close the border and impose tariffs. Let's remember that the U.S.-Mexico-Canada trade agreement, the USMCA, has not yet been ratified, and that's a very important priority for the Mexican government to get that done. So I think that theoretically, they could use their leverage to say they'll no longer acquiesce to the migrant protection protocols and allow third country nationals to come to Mexico. That would be leverage they could use against the U.S. government. But this administration has not really shown that it wants to play hardball with the Trump administration.
Yeah, despite the fact that there's obviously significant domestic pressure on them to reconsider or at least rethink their ongoing cooperation with the Remain in Mexico program. I would say the last thing to know is, obviously they're supporting the United States with the Remain in Mexico program, but they have been doing obviously a significant level of immigration enforcement on their southern border. And I think that they will probably continue to do this regardless of whatever happens next, largely because the Mexican public wants to see a reduction in the arrivals of Central American migrants. So at least in terms of cooperation, I think that's one area that won't be changing.
Okay, when we come back, is Remain in Mexico working? Under the Migrant Protection Protocols, or Remain in Mexico policy, certain migrants seeking asylum at the southwest border are sent to Mexico to await their asylum hearings. The administration claims MPP has reduced the number of migrants arriving at the border, but immigration advocates say these immigrants are being exposed to danger in Mexico. Cris, how does this decision highlight the differences you've discussed previously between these bilateral asylum cooperation agreements and other asylum management agreements?
So I think, there's sort of three key findings. One is in terms of data sources. The United States government hasn't published any systematic data about the number of migrants that have been returned to Mexico under this program. They've only published sort of general cumulative estimates towards the fall of 2019. There are other data sources that we consulted for this blog post that I wrote. For instance, the Transactional Records Access Clearinghouse, which is also known as TRAC at Syracuse University, is sort of tracking these returns through the immigration courts. And, they are kind of trying to get a sense of that. That's key finding number one. But if you look at sort of the existing data and the public records that do exist, you do see that an increasing number of individuals have been sent back to Mexico under Remain in Mexico. If you look at January, the data that we found, only 14 individuals were returned in January 2019. This grew to a cumulative amount of 55,000 by September 2019. And that was, that is significant. It's a significant expansion in the program scope. But I think the most important finding is that we did a comparison of cumulative returns under MPP and cumulative apprehensions out the southern border between January and September. And what we found is in terms of, how many individuals who were apprehended were diverted into MPP, it was only 8.6%. This is pretty important because if you're thinking about the total number of people who are arriving during this period to the U.S.-Mexico border, the apprehensions were increasing. That the fact that the program didn't have as a significant dent on those apprehension numbers raises a lot of questions about whether or not the program is effective. The caveat there is that if you track monthly returns under MPP and monthly apprehensions do drop as monthly returns under MPP increase. But of course, obviously, when apprehensions drop over the course of a year, there's other reasons for that. So we don't have definitive proof that was connected. But those are the three key findings from the blog post.
So what do we not know that we should know to improve our understanding of whether Remain in Mexico is doing what the administration intends?
I think first and foremost, we need to have monthly return data of the individuals that are returned every month, not unlike what we already do with Southwest apprehensions. This would allow us to understand, first of all, how many people are being returned. If we could see the populations in particular, families and individuals, to get a sense of which populations are being affected. That would also give us a sense of who's being sent into Mexico. And that would allow us to be able to, calculate cumulative amounts to sort of be able to do the math that we did for this blog post to say, how many people were diverted from apprehensions into Mexico. That's sort of things that are feasible to do this if you can publish those numbers. But if I had a wish list, the other core thing that would be effective is that idea of how many people who are being apprehended are sort of being transitioned into this program. And I think the other thing, and this is a little bit more difficult, but if I could wave a magic wand, is where are they being sent in Mexico? Because I think at this point we don't really know where they're being sent in Mexico, and it's, as I've said on Twitter, is that sort of a black box. Once they're returned to Mexico, these individuals eventually have to show up to the United States for the immigration court hearing, but what they're doing in Mexico and where they are is kind of a mystery.
Are we likely to encounter similar issues as these bilateral asylum agreements with Central American countries take effect?
Yes. I think at this point what I'm starting to see is a repeat of what happened with MPP, where you see some organizations or some reporters who are tracking the returns, but at least we haven't seen published numbers from the government that indicate the number of people who are being returned. The Hill did see a CBP document that said 322 people have been enrolled in the ACA Guatemalan agreement. But once again, at this point, it doesn't seem like anything's going to be tracked. So I'm guessing that we may be seeing something similar where the government publishes something in a few months saying this number of people have been returned to Guatemala, and eventually Honduras and El Salvador under those agreements. But we may not be able to get a sense of really what's happening there, and it may end up being yet another black box.
The break, collecting DNA at the border, and Harry and Meghan's immigration challenges. This month, the Trump administration announced it would begin collecting DNA samples from certain migrants arriving at both the southern and northern borders as part of a new pilot program. Many took this as a new effort launched by this administration, but it in fact is part of a 2005 law called the DNA Fingerprint Act. The Department of Homeland Security sought and received a waiver in 2010, and that exemption is now ending. But still, questions remain about how and whether migrants' privacy will be protected. Theresa, I gave a brief overview in the intro of the history of this law, but give us the full sense of the scope of this effort and who's impacted by it.
Sure. So as you mentioned, the story starts back in 2005, just a couple years after 9/11, when Congress passed and President George W. Bush signed the DNA Fingerprint Act. And that act required the Attorney General of the United States, gave them the authority to collect DNA samples from anyone who is arrested, facing charges, or convicted in the United States. So this law is already in place for people who are arrested in state and local jails, at federal facilities, anytime the United States government interacts with them in the criminal justice system. The DNA is being collected. The law also authorized collection from non-U.S. citizens and non-U.S. persons who are detained under the authority of the United States. So this opened up a question about what does detained under the authority of the United States mean when we're talking about people arriving to the United States or non-citizens in the United States. In 2008, DOJ published its its regulations on this, and in part because of these questions and a lot of back and forth between DHS and DOJ about really operationally how would DHS implement this at its facilities. I remember at the time DNA collection wasn't all that simple necessarily. There weren't rapid DNA tests like there are now. So in those regulations, the Attorney General gave the Secretary essentially the authority to request a waiver based on operational exigencies or resource constraints. That waiver was exercised in 2010 when DHS Secretary Napolitano signed an agreement with DOJ Attorney General Eric Holder that waived collection for most of DHS's operations at the border and inside the country, that they would not regularly collect DNA as part of this. The other thing to understand is that this collection was not for DHS purposes. The DNA collected is transmitted to DOJ and held in a DOJ database called CODIS, along with all of the other DNA collected all across the country. And the point of this basically is to be able to have a DNA data bank to match for criminal investigations, for terrorism investigations, when there isn't other physical evidence available to try to identify perpetrators of crimes or terrorist acts. So that's where this all goes back to. Fast forward to last year, in October of 2019, the Department of Justice published a proposed rule that would take away that waiver authority. It would take it out of the regulation, thus nullifying that 2010 agreement between DHS and DOJ. So now DHS is going to be required to collect these DNA fingerprints. In order to understand how to do that operationally, DHS announced that it would begin this pilot program for people that it quote unquote detains, starting in Texas, in El Paso, and also on the northern border near Detroit. The population that they're going to start with are people that basically have to go into secondary inspection, people whose ability to enter the United States is being questioned and they haven't yet been admitted. Anybody who does go into immigration detention from there. And the swabs are the cheek swabs, the rapid DNA testing swabs. They did publish a privacy impact analysis for this. And again, these samples are not being necessarily kept by DHS. They are going into the DOJ database to be merged with the rest of the criminal database information they have there.
So what are the concerns around privacy that some advocates and some migrants have raised?
So a lot of the questions are about who is covered by this. Remember, the law as originally passed applied to U.S. citizens. This particular provision was about non-citizens encountered at the border, but you also have permanent residents who do have rights in the United States, and whether it would be administered to them. At least for now, DHS is saying that it would apply only to U.S. citizens who are kept in custody pursuant to judicial warrants. So the CBP, for example, encounters U.S. citizens at the border who have criminal warrants outstanding, and they can execute a criminal arrest of them at that point and turn them over to other law enforcement agencies. They would be subject to this collection. Permanent residents, again, who are being detained, maybe they are not, they've committed a crime and they're questioned whether or not they're continue to have non-immigrant status or they have other warrants, and non-citizens who are being detained for inadmissibility purposes, or, for example, for those apprehended by Border Patrol along the southwest border and detained for removal proceedings. All of those would be subject to this.
As I understand it, this is not the first pilot program that involves collecting DNA from some migrants, correct?
Well, correct. And there was news last year about a pilot project that DHS and Customs and Border Protection had implemented with regard to families arriving at the border of DNA testing parents and children to determine whether claimed family relationships were correct. That used the same technology as this, the rapid DNA swabs. But the point of it was not under this particular collection regime. And the point of that was fundamentally to determine whether or not a claimed familiar relationship was in fact the truth. CBP had some evidence that there were false parental claims being made, and that by taking DNA, they were able to determine whether or not the person claiming to be parent in fact was. The pilot program was successful from DHS's perspective in that several people, upon being told or asked if they would submit to DNA collection, it was voluntary, admitted they had made a false family claim. Others went through the testing and then were found to be not related. The majority were related, but they did find that there was some fraud going on there. And that
So is this new pilot program a major shift for DHS? And if so, how?
I think the biggest shift is going to be operationally, particularly as the blanket waiver is gone, and DHS is going to have to figure out how to implement this law, which has been on the books since 2005, at all of its locations. That's every border facility, every airport, every immigration detention center, every place where it has people that are quote unquote detained under U.S. authority. They're going to have the ability to do this collection, maintain the samples, transmit them appropriately. This is the operational logistic thing that, frankly, DHS has been concerned about since day one, because CBP and Immigration Customs Enforcement encounter multiple millions of people each year who theoretically could be subject to this. That is a very, very large amount of collection and maintenance and transmission. And again, DNA is only as good as that custody sample. If there's any problem with that sample, if it gets disturbed or contaminated as it's transmitted, all of that kind of stuff really matters. So I think that's going to be a big operational challenge for DHS. On the privacy side, again, I think the expansion of DNA collection generally has been a concern of privacy advocates, both in terms of immigration, but also just generalized law enforcement. However, law enforcement officials will tell you that in many cases, DNA evidence is and has been the primary evidence that has resulted in crimes being solved. And also the reverse, accused being exonerated. So it's very important. That's one of the reasons the law was passed in 2005. Its application to the immigrant population, we'll see how it's used. I think that's the best way to say.
All right, finally, before we close, I have to ask about the latest developments with our favorite Brits, the Duke and Duchess of Sussex. We talked about the immigration angle when their son was born last year, and now that they've announced they're stepping back as senior royals and intend to split their time between the UK and North America, we've got another immigration issue to discuss. So if they're going to live and presumably work in Canada, as some speculate, they'll both, we think, need some kind of immigration status. What are the options available to them there? And if the easier path were the United States, where just Harry would need some kind of status, what are his choices here?
So in terms of, there's two ways of looking at it. I'll look at the sort of the employment-based side, and Theresa will look at the other options. So Canada, you're able to work in Canada in two capacities, and we're working on a project that's looking at this, which we'll talk about in a future podcast. But individuals are able to work on a temporary basis in Canada, but they're also able to access permanent residence through their merit-based system. We've talked about that a couple times here. Obviously, Meghan is a U.S. citizen, so if she wanted to go through, become a permanent resident there, she would go through their points-based system, which involves, an assessment of her background, personal and professional and academic. And if she does well on the points assessment, you need 67 out of 100 points to be able to move into a ranking state where basically you're ranked against other similar candidates in the pool. And if you're at the top of the rankings, then you're invited to apply for permanent residence. That's more or less the process that she could go through if she wanted to be able to live in Canada for an extended period of time and be able to work. I think, though, for Harry, it's a little bit more complicated.
Yeah, so I would take a step back and a couple things. The announcement was short on details. What it said was they want to become, quote unquote, financially independent, which means somehow earning an income outside of the royal treasury, and that they wanted to split their time between UK and North America. Now, there's some conclusions we draw from that. Harry is, of course, a UK citizen. As far as we know, he doesn't have citizenship status in Canada, even though Canada, as part of the Commonwealth of Nations, Queen Elizabeth II, his grandmother, is the monarch of Canada. She is queen in right of Canada. And therefore, Harry, as her descendant, also has royal provision in Canada. That doesn't necessarily give him citizenship. Meghan is a U.S. citizen, as far as we know. She was in the process, as we think, obtaining UK citizenship. As far as we know, she hasn't given up her U.S. citizenship, so she obviously could come here. But as far as we know, she has no status in Canada. So the next question is, do they want to get permanent residence? Do they want to actually get a green card in the United States or landed immigrant status in Canada? Or if they want to split their time, are they just looking to have some sort of status that allows them to stay for a while and work while they're here? Those are important questions because the kinds of visas they could go for would be different. In the United States, since Meghan is a citizen, if she wanted to sponsor Harry for a green card, she could, and that process would be relatively straightforward. Could probably get done within a year. But being a permanent resident means that you're claiming that your primary residence is in the United States. Also, and this is very important, permanent residents in the United States and U.S. citizens are taxed on their worldwide income. So suddenly, the royal income in UK would be subject to U.S. taxes. That may or may not be a consideration for them, but it probably is. So I'm guessing that the United States will not be their primary home. It's probably more likely, again, because of the royal connection in Canada, that they might live and work in Canada. Meghan has already worked in Canada as an actress. She was able to obtain a work visa there. That probably is another thing, particularly if she's going to resume her acting career, that she could do. They are starting a foundation, a charitable foundation. If that is based in Canada and they are working for it or somehow overseeing that, that probably would require a different kind of work visa. And again, it's a matter of time. Are they looking at landed immigrant status or temporary status? The whole point of this is it's all wild speculation, but it's not unique to them. There are people in the world all the time asking these exact questions. If I want to live and work in another country, what are my options? How do I do it? What are their obstacles and hurdles? It's nice to believe that somebody in that status could just pick up and move, but they actually have to face these immigration questions.
Cris, did you have more that you wanted to add on the U.S. route?
Yeah, on the U.S. route, I mean, the thing is, this is where you're gaming out an interesting scenario. On Twitter, I was talking about Harry potentially going through the employment-based green card sponsoring process. Obviously, Meghan could sponsor him as her spouse, but if for some reason he got an employer to sponsor him for a green card, that could be another way that he could get permanent residence. The one that got, I think, a couple of laughs from people is Harry applying for an H-1B, temporary high-skilled worker visa. That would be interesting.
We don't know if we get it.
Yeah. But I think that's the reason it's funny. I mean, if you actually think about it, I mean, that would expose him to a lot of the uncertainty that people who are temporary immigrants would face in the United States. That nothing is guaranteed when you're an H-1B, when you're working here on a temporary visa on that. But I think it does say a couple things about the importance of permanent residence. I think when you're looking at sort of your capacity to live and work around different parts of the world, obviously citizenship is kind of the highest level of sort of the rights that you can get to be able to live and work in a country, and to be able to participate in full public life. But permanent residence, I think, is really important because it does give an individual or a couple the capacity to be able to make their home somewhere else and maybe be a little bit more mobile and be able to sort of settle down. And I think that's sort of very important when you're looking at this, is just how the role of permanent residence is being considered, especially when you're looking at more globally, that there's a model of immigration that's coming out of, people kind of tend to refer to it as the UAE model, the United Arab Emirates model, where essentially all migrants are temporary migrants. Nobody can get citizenship. And permanent residence is really not an option. And you are seeing a proliferation of this model going around worldwide. So in a way, it's sort of interesting to sort of see permanent residence as something that's important for allowing immigrants to integrate, especially when you're seeing another global approach to immigration that I think is certainly limiting and restricting that and treats immigrants as temporary migrants.
I think the only thing I would say is that I am sure that there are no shortage of immigration lawyers in Canada and the United States who would be eager and happy to take them on as clients and try to figure this all out for them.
That's probably as good a place as any to leave this discussion. Thanks as always for joining me. We'll be back in 2 weeks. In the meantime, please take a second to find us on Facebook by searching Bipartisan Policy Center, or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. Just search Bipartisan Policy Center. I'm Jordan LaPier. This Week in Immigration was created by Theresa Cardinal Brown and myself. The executive producer of This Week in Immigration is Theresa Cardinal Brown. This week's episode was written by Cris Ramón and myself, and produced by Cris Ramón, Yafat Tawahara, and me. Our editor is Yafat Tawahara, and the executive producer of BPC Podcasts is Ashley Swearingen. That's all for now. Join us again next time on This Week in Immigration.